Hi everyone. Today's lesson simply explains the law of succession in the legal system. So you'll remember in the previous video we're dealing with the general background of the law of succession. So in this section we are specifically dealing with the law of succession in the legal system and mainly focusing on the material rules of the law of succession, both of them which are common law and customary law. They operate in a private sphere and they are the ones that are prescribing what becomes of a person's estate after death, who the beneficiaries are, and what they will inherit. They also go to the extent of identifying different rights and duties of persons in respect of the deceased estate. So the process by which the deceased estate is being liquidated is known as the administration of estates. During the administration of the estates, the office of the Master of the High Court is involved, and that doesn't mean that the rules of the law of succession operate in a public sphere, because the office of the Master of the High Court is a public institution. So one would be inclined to think that the rules of the law of succession operate in the public sphere. No, they operate in a private sphere. That is why we are saying the law of succession is forming part of the private law. So coming to the origins of the law of succession, it is placed in different places because you find the influence of the Roman law, you find the influence of the Roman Dutch law, and also find the influence of English law in the law of succession. So starting off with the influence of the Roman law, you will remember that private property right and the right of persons to dispose of their assets by means of a will, that is a testamentary bequest, was known in the Roman law. It was an extreme disgrace of a person to die intestate in the Romans. So an institution of an heir was a validity requirement in the Romans' will. And the testator was also required to bequeath some of his or her property to his close relatives. That was known as the legitimate portion. So the testate succession in relation or as opposed to the intestate succession played a dominant role in the Roman law. Then coming to the Roman Dutch law. The Roman Dutch law had the influence of Germanic, as much as some Roman influence were there, but it had the influence of Germanics in a sense that the institution of an heir as a validity requirement was not in the Roman Dutch law, but it remained the legitimate portion. So South Africa simply inherited several testamentary forms from Roman law and Roman Dutch law. And the different provinces in the country simply promulgated the legislation which was mainly in the English law, which was in the English Act, which presided or dominated in early days of our history. So the testamentary forms imported this way were known as the underhand or statutory wills. So as much as the South African law of succession is influenced by the Roman Dutch law, but the English law also has an influence. For instance, taking the interpretation of will and the execution of wills, that influence is emanating from the English law. So this is the extent of the law of succession in the legal system. So in the next video, we will be dealing with the dual character of the law of succession. So I just hope that we've clarified every single aspect that we wanted to clarify. Thanks for watching the video.